Welcome to the NC DWI Guy podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI Guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to another episode of the NC DWI Guy podcast. Today, we are very privileged to have the recently retired Chief Public Defender of Buncombe County, LeAnn Melton, on the podcast with us. LeAnn started as chief in 2008. She was an assistant public defender before that, going all the way back to 1996. I started practicing in the Asheville area in 2009. And so for my entire career to date, it was always LeAnn that was the public face of the public defender's office. I can remember many times early on in those early years, I probably didn't even know what the difference between chief and assistant was in terms of the public defender's office, or what everybody's role was, chief district court judge and all these things. I was just trying to figure out how to handle a speeding ticket. But I can remember many times in the early years of practice, LeAnn, how you would just be willing to take questions. You were always very approachable, sitting in the courtroom. If I had to bounce an idea off of somebody, if I had appreciated who you were in terms of what your role was, I probably would have been too embarrassed to ask my questions. But you never made me feel uncomfortable about kind of bringing an issue or a topic, or how to make a bond motion, whatever it might be. You were always available to bounce questions off of, and I really appreciate that approachability. So thank you very much. We're deeply honored to have you on the podcast.
Well, thank you for inviting me. I'm looking forward to our conversation.
Yeah, I am too. And, I think maybe a good place to kind of kick things off would be just in terms of the amount of time that you got to spend in the public defender's office, and really just in kind of criminal practice, in state criminal practice. Going back all the way to 1996, I mean, 25 years ago, 25 years of experience on that end of things. What are some of the kind of biggest changes that you've seen take place in terms of how criminal cases are handled, whether that's in terms of, what issues that a judge is kind of looking at, how sentencing goes, any kind of really just opening it up? What are some of the biggest changes that you've seen during that time frame?
I think during the time I've been in the public defender's office, there's been a real shift from more of a focus on from it being from punishment to more on treatment, especially in the district courts. We've had so many diversion opportunities and treatment opportunities over the 24, 25 years that I was there that have come up. I think it was around 2009, the JUST program started in Buncombe County. Kim Moretz, who retired about a year ago from the county with pretrial release, was very instrumental in bringing that program and it was designed to help individuals pretrial who were diagnosed with severe persistent mental illness. And it's been a great program, JUST program. Judge Young was involved with that, the district attorney's office, and it was modeled after the Jericho project in Memphis, Tennessee. We've had nuisance court come through as a diversion program.
I spent many days in nuisance court.
Yes.
I always liked nuisance court. There was something that just felt like the room that was in the courthouse, was really too small for the amount of people that were involved in the program, like the courtroom that it was in. But I just thought it was such a great court. Like Judge Hill just really, did a great job, I think, with kind of communicating to people in that courtroom. And that was really my first experience with like any of these diversion programs on a consistent basis. I had a lot of clients that went through the nuisance court program, and I just thought it was a great program.
Definitely. And we had DWI courts, sobriety courts start. I guess that was sometime around 2013, 2014. We had Corrective Solutions, a for-profit diversion program, and then that changed, the county funded. a free diversionary program with the Justice Resource Center. And I really think that the Justice Resource Center became a game changer. I mean, it was equal access for everyone, for different treatment options and the ability to keep charges off their record. We, during my time, we started doing H&I felony pleas in district court. That changed, and we stopped doing the H&I felony pleas. I will say one of the biggest changes, and I guess was a game changer for criminal justice reform in Buncombe County, was the Safety and Justice Challenge through the MacArthur Foundation, which was in 2018. There's been a real concerted effort among all the stakeholders, I believe, in talking about real criminal justice reform and starting that conversation and rethinking how we utilize our jails. I think it's been fabulous to have that. The county has now become very involved in helping, especially like I mentioned with the Justice Resource Center. They funded that program. They saw the need and they were willing to do that. They started in, I guess it was around 2018, 2019, the county finally started funding a position in the public defender's office. The public defender's office is usually all state funding. The county, for many, many years, funded positions in the district attorney's office, numerous positions, and I had fought for years to get a social worker position in the public defender's office, and the county saw the importance of that and did fund that position, and it's worked really well in the public defender's office. We got electronic discovery in district court. I think that's...
When would that have been? Like, do you remember kind of roughly the year?
It was around 2009, I think, okay. 2009, okay. 2010. I think they were, the district attorney's office, when they were beta testing it, sent me the first electronic discovery in one of my cases to see how it would work. And, and I think it's just, our discovery is so voluminous now, especially with body cam footage and so forth, which we used to not have. For me, to be able to, I love electronic discovery. You know what you have, and it's easy access to the information. So,
yeah, that's awesome. I think really kind of that, movement away from maybe punishment, and it doesn't mean that that's the situation in all cases, but the move away kind of in a kind of large scale format from punishment to kind of treatment based programs is a movement that has kind of been a big movement over the last couple of decades, but certainly the last decade, and continues to kind of, I think, move in that same direction. And I think one of the things that is always kind of interesting in terms of trying to figure out how to get some of those programs off the ground is there are so many people that are involved in something like the DWI treatment court or the justice initiatives that you were just speaking about. There's a lot of players that have to kind of get to some extent on the same page. And I would assume that at most of those kind of initial meetings or, kind of like, how do we move forward in this direction? I would assume had a seat at the table. So in terms of kind of talking about the dynamics of getting people that kind of have all kinds of different interests that they're bringing to the table, the district court judge's office, the state, people that are in social work, I guess in general terms, what does that look like in terms of how to get, people to communicate or to kind of start down the path towards something like a, DWI treatment court or kind of jail reform, that type of thing?
Well, I think, so the good thing about in Buncombe County, back in 2007, I think something was started. It was called the Justice Advisory Group.
Okay.
And at that time, you had the district attorney's office, you had the head of the jail, the public defender's office, I think I said the DA's office, and you had the judiciary there. And we would have the informal lunch meetings, and we would just talk about ideas and ways to improve things. With the DWI court, Judge Keppel was instrumental in that. And I think also the district attorney's office was very instrumental in that. We had numerous meetings about what it would look like. I think the county provided some funding, and I think it was also through the Governor's Crime Commission for some training in Athens, Georgia, with model courts to see how they did things. And that was invaluable to see somebody who's already invented the wheel, to see how that they do things. And
that's awesome.
And it was a bonding. It was, you were in a different jurisdiction. You were spending the night in a hotel. You would go out to get to dinner together, and you would really hash things out, breaking bread with one another.
That's awesome. Yeah.
And I will tell you, there were times that things got pretty contentious, but less contentious, I think, because you were in that type of environment and not at the courthouse when you were discussing a lot of those issues.
Yeah, that's such a cool thing to think about, how that changes the dynamic of the relationship. Even when you're talking about kind of the justice reform and having the lunch meetings, to kind of start things off, just having that kind of less formal setting to discuss these big issues, when you're not talking about it in the specifics of a particular case, you're not talking about it in the courtroom with somewhat the public eye kind of watching over everything, that ability to have, kind of intimate conversations, where it can then kind of veer off to anything else over the course of a lunch. But then certainly when you're kind of going on a retreat together, so to speak, or a conference together, where there's, a lot more opportunity for that kind of less formal conversation to happen. I think that's just such a beautiful thing for the state and the defense to talk to one another, for the defense and the jail to talk to one another, for the judges to hear feedback, kind of outside of this adversarial process of what really works. Maybe there's times when I perceive that defense and prosecution are on really different sides of the aisle, when in fact they're actually, kind of arguing the same position. So that's really a cool thing to hear.
Yeah. And as part of the Safety and Justice Challenge, before pre-COVID, the judiciary, the district attorney's office, the public defender's office, pretrial, the sheriff's department. We went to Chicago, we went to Houston. There have been some other places, and they would, and a lot of times they would rotate who got to go, but just to have those very non-threatening conversations, non-adversarial conversations in a different environment, I really think helped move the needle, and anticipate. There's just such good people, at the courthouse right now, in the DA's office, in the judiciary, in the public defender's office. I look for even more treatment options to come in the future.
Yeah, I agree. I think building that, even if it's not already at the point that you're kind of walking down the road to that kind of model, courtroom and kind of going through this kind of conference program and training program together, where it's now kind of somewhat formulated, we're moving in this specific direction. I think those confrontational conversation, or not necessarily non-confrontational, but the less formal conversation opportunities really start to build the ability to do that. So for instance, the attorney lounge in Buncombe County, I think, is just such a beautiful place for an exchange of ideas. And I've seen judges in that room, and I've seen, DAs in that room, and certainly, members of both the public defender's office and private defense bar, engaging in conversations in this, less formal setting that kind of helps then build the bridge for understanding issues in the future, or kind of saying, okay, if we're going to engage in this particular project moving forward, maybe these are some of the key players that might be able to do that, because of the, free exchange of ideas that's happened in that less formal setting.
Yes. And I will say, when in terms of the DWI court, and the private defense bar played a key role, I think, in terms of helping to shape that court. I know that there were meetings that Judge Keppel had with the private defense bar and the public defender's office to talk about what the court would be like and get feedback and input. So I think that good communication back and forth was very important.
Yeah. I guess in terms of, ways that the, public defender's office and the private defense bar has kind of worked together in, Buncombe County, or as you've seen it over the years, what are some of the ways that you've kind of seen, a strengthening of that relationship, or any of the, initiatives that you had in terms of trying to kind of strengthen the, whether it's just the defense bar or, kind of the local bar as a whole? What does that look like over the, time that you served as a chief in the public defender's office?
Well, I mean, I will tell you that I think the game changer, and I think when Megan Burke spoke in your video with her recently, was the listserv that she created, the ability to have that instant communication with the entire criminal defense bar. It just, we were informally organized, I think, before that, but I think it just brought everyone. You can have your individual conversations with people, but you can effectuate a lot of change when you have everybody together at one time. And I think that that listserv allowed that. And then just, the private bar giving feedback and the public defender's office giving feedback. We're just telling everyone everything, what we agreed with, what we didn't like, what we thought should be changed. For me, having that listserv and knowing what the private bar's concerns were without revealing confidences, I could talk to the judiciary or talk to the district attorney's office, this is a concern. Can we can we make this change and so forth? I think it gave the defense bar more of a voice.
Right. Yeah,
than
absolutely.
What we had. And, and I think it's been key to help the improvements that we have here. I know that, there were different things that I think brought the defense bar together, different issues. There was an initiative back in 2013, 2014 that I think the defense bar had a lot of concerns about in terms of the impact that it would have on our clients. And because of that listserv and how then the defense bar was able to get so organized so quickly, the defense bar was able to have a huge impact on how that program ultimately ended up. And that's just invaluable. I think in the past, back in like 2010, 2011, the defense bar would have meetings over at the Ritz, which was a restaurant that Gene Ellison had, and upstairs, I think it was a bar area. And we would have, in judicial elections, we would have the judiciary come and speak. And then we would have, some informationals. We had an attorney come in one time to do a talk about immigration consequences. But that listserv was really the game changer, and Megan Burke organizing the defense bar. We kind of became a one voice, which I thought was very, very helpful. I know that the Justice Advisory Group ultimately became the Justice Resource Advisory Council several years ago, and that really started around the time of the Safety and Justice Initiative.
Okay.
And I know that even though we were one voice, sometimes public defense and private defense, our goal is the same, but the way we get to that goal may be a little bit different. Like with diversion programs, I was very vocal against the for-profit diversion program because public defender's office clients who were poor, the equal access argument.
Right.
Private defense bar was more interested in having diversion opportunities.
Right.
The private defense bar clients could pay for those opportunities, whereas I wanted a diversion program, but I wanted my clients to be able to have access to it. When the county decided to do their diversion program through the Justice Resource Center, some stakeholders wanted there to be a fee for it. I was adamant against there being a fee. Private defense bar, ended up, some of the private defense bar ended up taking the position that they were okay with the fee. Ultimately, the county, and I totally understood that. I wanted the diversion program. I did not want to kill it, if that makes sense.
Right.
But so the private defense bar needed to have a seat at the table because, my job is public defense as the chief public defender and criminal defense. The private bar, we have the same goal, but we have different ways to get there and different needs. And I will say that was the best thing that ever happened. There were some stakeholders that objected to that. It was either an either or, either the public defender's office has a seat or the private defense bar has a seat. Ultimately, the judiciary was very supportive of having both the public defender's office and the private defense bar, and it's been fabulous. I know that the representation of the private defense bar, when we had the resolution up for a vote, the declaration of declaring racism as a public safety emergency, the private defense bar was very instrumental in helping that get passed. And two are always better than one. So I'm glad that we have two at the table. So.
Yeah, no, I agree. And I think, it's interesting, again, just with kind of how relationships drive some of these programs forward or drive even the kind of communication forward. One of the things that I think was problematic about the, a privately run diversion program is I believe that the company was based out of state, California or something along those lines. And, that just makes it very difficult to then kind of communicate with the people that are running the program and kind of how do you maybe make an exception in this particular client's case, or, what is the, what are we trying to do through this program for the local community when the person that's overseeing or the entity that's overseeing it is not really a part of the local community. So again, I think that, having that kind of relationship based diversion program where you're kind of, you've got people that are literally sitting down at the table. Again, we've gotten so used to this kind of like virtual world where we're all interacting, like we are right now over a Zoom call or a Google Hangouts or whatever it might be. But I do think that we all kind of want that, relationship based model where we can kind of see the impact in the local community. And I think that kind of outsourcing of diversion, that kind of hands-off approach was really one of the things that led to its downfall because of the fact that there's just nobody that you can really kind of speak to in a meaningful fashion about why this case is different or, what the impact of this decision is for the local community or for this particular client. So I really think it is important to have those, relationships that are kind of driving everything.
Definitely. I mean, I think that, the idea of a diversion program was great. And I think the fact that we had that diversion program for a period of time helped it, grow into what we have now.
Yes.
So
yeah, absolutely.
If you don't try something new, you don't know what you'll ultimately get. So exactly. I think it actually ended up being a good thing because it changed into the Justice Resource Center.
Yeah, that's awesome. I totally agree with that. I think it's one of those things that you sometimes have to learn by trial and error and learn from your mistakes. And especially as you move from that kind of traditional, sentencing model where it's kind of like, let's just look on the grid in terms of where the results should be, right? To this kind of like, how do we address this, community issue, this drug problem, this addiction issue, homelessness, whatever it might be, mental health, like you were talking about, that becomes a lot less black and white in terms of how to address those kind of issues.
Yeah, definitely.
Well, I guess we kind of focus the podcast in a lot of ways towards younger attorneys, people that are kind of coming out of law school or recently graduated. And so, in terms of the things that you've seen in the courtroom over your many years of experience, probably district court in particular, what are some of the things that you've seen, kind of defense attorneys do particularly well? And I'll just kind of leave that very, very open-ended and vague. But what are some of the things that you've kind of seen be a point of a point that young attorneys should really kind of follow in line with?
I think humanizing your client is extremely important. And I've seen attorneys have a courtroom packed with community and family members, pastors, employers, and at sentencing,
that's what I call the James Mills defense right there. I constantly reference James on that front in terms of how he does it, because I love it. Every time he's got everybody lined up to speak, it's like, this is how it should be done right here.
It's just awesome, and it is extremely impactful. With the judge, I would say to a new attorney, one of the things is, when you see the really good attorneys in the courtroom, they know their judge. If they go to a new jurisdiction and or you have a visiting judge, they'll get on a listserv, or they'll call different attorneys that are familiar with that judge to know, these type of cases you want to stay away from with this judge. This issue works in front of this judge. Knowing your judge is hugely important. What arguments work and what arguments don't work. I would say the other advice I would have, and things that I have seen that lawyers have done that have been so good and so effective, are the lawyers who know the law, who argue it. They stand up to the judge. They argue their position forcefully, but they're always respectful. Because if you're not respectful, that could come back and hurt your client. If you've got the law on your side, argue it, but don't ever make it personal.
Right.
With the judge. And the other thing is, your reputation is everything. Your candor with the court. We can do a lot to zealously represent our clients, but just not cross that line. Because once you cross that line, it's going to be a very long time before you ever get that trust back with the court, and that hurts your clients if you don't have that trust. I'll just tell you a story, something that has worked for me, and it goes back to humanizing your client. I had a client a couple of years ago, and I had him on a felony probation violation. And he had some other charges that were in district court. But he had been alleged to have absconded from probation for years before he finally turned himself in. And he had turned himself in because he had found out that his partner was pregnant, and he wanted to get all this behind him so he could be there for his child. And so his child was born during the time period that this other attorney had the case. And so by the time I got the case, his daughter, I think, was like 2 or 3 years old. And he had totally turned things around. He had a job. He was doing really well. And he was in my office, and we were just talking. And I will tell you, I think it's hugely important to listen to your clients and hear their story, because you get these little nuggets, these tidbits, and everybody wants to be heard. They want to be able to tell their side. And he asked me if I wanted to see picture of his daughter, and I was like, yeah. So he had these pictures on his cell phone, and there was one, his little girl, cute as I don't know what, and it said, this baby is rated PG, pretty gorgeous. It was just awesome. And there was this other photograph where her head was lying on his chest, and you could just see the love. And so I told him, I said, I want to email these to me. I want to print them out and show them to the judge. And he seemed a little, like shocked. Why would I do that? But anyways, so I was in front of the Superior Court judge, and I did not want to see this gentleman go to prison. And I showed the judge these photographs. And the judge looked at me and he said, Ms. Melton, do you really expect that your client can do nothing for this amount of time, have been, gone for this many years, and you just show me these pictures and me not send him to prison. And I'm turning to my client at that point. I'm like, I'm so sorry. And then the judge goes, well, you might be right. And, he saw what
Yeah.
anybody would see in those photographs. And I think that's what made the difference. If that judge had not seen that love that my client had for his daughter, I think the judge ended up giving him 7 weekends in jail and terminated his probation. But being the biggest thing is show the judge who your client is. Your client is not just the charge. They're human beings. They have a life. And show that to the judge, and it can make the biggest difference in the world.
I totally think that is just such a great point of advice. There's attorney Navi Sandhu, who's down in our Durham office, and he has started having clients basically kind of as soon as they're charged, kind of write out a letter to basically kind of reflect on, why this was a bad decision, what went wrong. And then basically throughout the case or throughout the time that the case is pending, continue to add to that. So almost like a journal of, what went wrong this particular day, what things are going well in life right now, where am I going moving forward? What lessons have I taken away from this as I've had to go to classes or do community service or whatever it might be. And then at the end of the case, Navi reads this to the judge, kind of highlighting certain portions, but it's basically kind of, allowing, client's voice to come out to the judge in a very kind of like thoughtful and reflective way, but it's very much the client's voice. It's not Navi's voice that's coming out to the judge. And so we're going to try to kind of implement that across the board, because I think that is so powerful in terms of having those pictures to offer to the court of what does my client's life look like now versus the date of the charge. Like, clearly there's no way sometimes to undermine the, just kind of horrific thing that has taken place or the terrible decision that was made. It is what it is, but what has kind of like happened as a result of that? What life changes have happened as a result of that? And we're always looking to do that, but a picture is definitely worth 1,000 words when it comes to saying, this is what life looks like for my client right now.
Definitely. And I'll tell you, this may be a little bit more than what your question was asking for, but as part of the Safety and Justice Challenge, I stayed on the community engagement work group. And one of the things that the community engagement work group is talking about, and I've learned more about from that community engagement work group, is something called participatory defense. And there's a whole website. It's Silicon Valley Debug started it. But they call it time saved as opposed to time served. It really is community oriented. It involves the community and families working with the defense. And they have something that they train individuals to do life videos. And I may not be saying that correctly, but it's like a day in the life where most people now have the iPhones or the Androids, and we're so video oriented now, where they'll film like, interviews with a pastor, or show the client, at work or in their church or doing something. And instead of the lawyer, being up there, my client's 33, they have 2 children, they work so-and-so, it's the video that tells the story. And they have had huge success.
That is awesome.
Amazing results, for sentencing, and videos that can be shown to the district attorney to say, look, this is why you should do something special in this case, and really, instead of talking to someone, you're showing someone. And I just think that can be.
Oh, that's so powerful. I'm kind of laughing because we had this meeting with the team at the office last week. We had this time frame where we were trying to come up with what I was calling golden ticket ideas. So like ways that we can improve like the value that we're bringing to clients. And that was actually one of the ideas that got offered, was this idea of like, how could we, have the client film themselves, 2 or 3 days after the charge, when they've kind of hit rock bottom as a result of that charge, and then, a couple months later, film themselves again. What lessons? Kind of taking the written format and putting it in that video. So it's just funny to hear that. That's actually, I thought we were being really unique about that, but apparently that's like already being implemented. So I love it. I think that's so great.
Definitely.
Yeah, and I just a couple of other things that you had touched on in terms of, things that young attorneys can do. I think definitely knowing your judges is a huge point of reference, kind of being very aware of that. And again, not being afraid to talk to other attorneys about that, kind of process, or what do you think that this judge might do in terms of requesting, a bond reduction or whatever the issue might be, being, open to kind of communicating with other people in the defense bar as you're kind of coming out, learning, the court system and process, and not having a great understanding of maybe what a particular judge might do on a specific issue. The defense bar is there waiting for you to ask a question. So definitely ask away. So I really like that point. And then obviously, credibility is everything. I mean, it really is. It's the easiest way to kind of destroy the case that you're, arguing on, on this particular day at this particular time. But also, like you said, every case down the road, having those all now be questionable, it's just so hard to kind of bring that reputation back in. So that is a really important part of, and it's you got to be on that like 100% of the time. It's not about kind of just when you're in the courtroom, every conversation with the DA's office, every conversation with other attorneys, the clerks, whoever it is that you're working with. It's just, one shortcut can really kind of create a lot of problems down the road.
And I will say for new attorneys, there are so many free resources that are available now. The Indigent Defense Services webpage, they have all of their CLE trainings.
But do you know, LeAnn, is that ncids.org? Is that what that is?
I believe that's right. If you just Google Indigent Defense Services, North Carolina, it will come up. The School of Government has so many free resources now. UNC School of Government, the Criminal Law Blog. You can get jury instructions now for free. They're available on the School of Government website. The Public Defender Trial Manual, Pre-Trial Manual, the Manual on Raising Issues of Race, the Juvenile Defender Manual. Indigent Defense Service has done just such a good job putting so much information out there. It's available for free. So.
Yeah, that was one of the first things that I printed out of law school was that public defender manual that is created. I mean, it's great. I mean, it's got case references and covers every issue. And, you spend so much time in district court just waiting for your case to be called. Print that manual out and carry it with you into the courtroom. And then in all your free time while you're waiting for your case to be called, you've got, plenty of reading to be doing.
Definitely. And the other thing that helped me so much as a new attorney, I joined organizations like the Advocates for Justice. Mm-hmm. And that listserv, I remember, this is before I became chief public defender. I had a trial and I really wanted to assert an entrapment defense for my client, but I knew I couldn't put my client on the stand. And I was like, can I get that jury instruction if my client doesn't testify? And I was doing all this legal research before trial to see if I could get one. And before I went to bed, I was just like, it was the day before trial, I was like, I'll just send a question on the listserv. When I woke up in the morning, there was the case.
That's awesome.
And I was like, oh, I wish I had sent that email a long time ago. So
yeah, I think that those resources are invaluable. And I think I think that there's a little bit of an intimidation factor, especially if you read a lot of the listserv and see all the great answers that are put out onto the listserv. There can be a little bit of an intimidation factor in terms of posting a question. You don't want to sound like an idiot, but I think it's one of those things I've posted on there many times. And, the response is always quick. It's never condescending. I've never seen a condescending response. Like, you should have known the answer to that. So again, just ask away on those kind of listservs, because you're going to get basically the top level legal response that exists in the state on those, North Carolina Advocates for Justice listservs.
And I would say this can be very scary, I think, for a new attorney or for any attorney. But ask other people what you can do in the courtroom to improve. It's scary to get feedback, but I think most people will give you that feedback in a way that would be very constructive. Ask judges, is there something that I can do different? Talk to DAs. How can I improve my negotiating with you? What is it that you need to see? In these type of cases, what kind of documentation do you want? I probably drove people crazy asking questions, but it's like, it's your client's liberty. Don't just, you can't be afraid. And there is, as you said, there's no dumb question, because you're trying to help your client. So. Yeah,
you suggested that to me several years back, just to kind of, follow up with the judges. I also like the DAs. I don't remember if we specifically talked about that, but then after doing trials, I would routinely go up and ask the judge that question, what could I have done better? And a lot of times, I think the judge just didn't want to offend me. And they're like, not really, maybe they just weren't prepared for that question. I don't know. But a lot of times they gave, a really good answer. Like, I would have brought it out maybe this, particular way, or the reason that I sustained that particular objection was because you didn't walk down this road, with the questioning. So, it really did kind of open my eyes in terms of like, it's pretty easy to get better if you just ask somebody that is kind of a, casual observer of what's going on, how you can improve.
Yeah, definitely. I had a Superior Court judge one time. We were doing a jury trial, and we were back in chambers while the jury was out, and he was like, well, I was following along pretty good, in your closing argument, you said this, but why in the world didn't you say this? And then I was sitting there going, damn.
It is painful sometimes to hear that feedback, especially if it's right after the trial occurred. It's different when it's a couple of weeks down the road, but the Superior Court judges, especially before COVID, are traveling so much, you kind of got to ask right away. So it definitely leaves you hurting a little bit, sometimes. But I think that's a great piece of advice, is just asking people how you can improve. And I think even in terms of the relationship with like a DA that you negotiated something with, and then a couple of weeks later you go back to them and kind of ask for their advice on how you could kind of improve bringing that same case to them in the future. Even if there's not any constructive criticism that's helpful in terms of that relationship or relationship with other DAs, I think you build the relationship with the DA that you kind of say, I care about your opinion on this, right? Like, it's not just a matter of kind of getting that feedback, which is extremely important and worthwhile in and of itself, but you're also kind of just being able to extend to the DA another kind of opportunity of like, I really appreciate your advice on things. So I think that's a really great way to build the relationship.
And I will say, back to advice to new attorneys, one thing I can say is, when you're arguing before the court or when you're negotiating with the DA, show the court and show the DA that you care about the client, or that you believe in the client's case. Because I think everyone is human. And if the DA sees that passion that you have for the client, or the court sees that passion that you have for the client, and I can find something that I like about any client, and focus on that. And it goes back to making your client human before the court. It can tilt the scales, I think, in the court's decision or in the DA's decision, because we're all human. And I think, the judges, they're watching the defense attorney's reaction, and the DAs are watching the defense attorney's reactions, and how that defense attorney interacts with the client in the courtroom. I think the court sees a lot that's
Yeah,
going on
exactly.
in
Oh,
that courtroom.
absolutely.
Be mindful of that.
Yeah, no, that's a great point. Yeah, that's a great point. I love that. I guess on the flip side, are there anything that you see as a particularly like bad practice to say? Again, obviously, upholding credibility. The easy flip side to that is don't do anything unethical. But are there any particularly uh, you know bad practices that you've seen that people could kind of steer away from?
Um, I think that not being prepared, not knowing the case, not having talked to the client. I mean, at the court, I think, and the DA can tell whether or not a defense attorney knows the client's story.
Yes.
I think
Yeah.
you cannot underestimate the value of being prepared. I think, unfortunately, our court system is so overwhelmed. Sometimes you can't be as prepared as you might want to be. But I think that can be one of the biggest mistakes. If your client is in custody pre-COVID, I would say constantly be over at the jail talking to that client, keeping them updated on the case, learning, what the client has to say about the case. I've had clients who've looked through their discovery, who are over in the jail, tell me stuff that I would have missed.
Yeah.
Because they know, many times clients would know the witnesses or know who was involved and would be able to pick up on things that I, as a defense attorney, wouldn't be able to. But I guess if I had to sum it all up, is the biggest mistake I see is when attorneys are not client-centered. I guess is the best thing that I can say. At the end of the day, it is really all about the client. And that's what I tried to have the focus be in the public defender's office. And I think I want to throw this out there. I think our bar is just awesome. And
Yeah,
I will say that I've had so many attorneys in the private bar help me over the years and listen to my questions. I've had private attorneys see me cry, being upset about what happened, in a client's case. I mean, David Belzer, Bill Allman, Sean Devereaux, Steve Lindsay, Al Messer, Megan Burke, I don't want to leave people's names out, but, we are such a resource
Yes.
to each other, giving each other motions, bouncing ideas off of each other. It's almost like a family that we have here in Buncombe County.
Yeah, I agree. And I think, maybe kind of piggybacking off of the discussion that I'd had with Megan a couple of weeks back, and just kind of what you said just now. I mean, I think that if you don't have that kind of bar, and I don't think there's many places that doesn't exist. Maybe it's at different levels, each location, each county that you go to. But if you're at odds with your bar, then that is a huge handicap to your practice. Like if you're not kind of contributing to, throwing cases off of somebody else or being willing to answer a question, then you're really a handicap to the defense as a whole. I think the more that we work together and support one another, and it's been such a huge blessing in terms of practice. One thing that I've really found in terms of my time in Buncombe County has been just how helpful other attorneys have been on the case, sharing motions. And I mean, I know these people put 20, 30 hours of time into this motion that they're just giving me free, right? Like, I mean, there's no expectation of anything in return. It's just like, hey man, I want you to win this case for your client. Like it's such a cool experience to have other people that are willing to support you. And I think I did a little bit of civil practice at the beginning of my career, and total different, dynamic, even between the state on the other side of the V. I mean, it's just a total different dynamic was my experience in civil litigation. Very, very visceral, and not a lot of help coming from other people in the civil bar. So, I just think that was what really kind of made the criminal defense practice actually very, very inviting. I mean, it was just such an inviting place to practice law was, the criminal defense bar in Buncombe County. So I totally agree with that.
Yeah. I've had serious like murder cases or felony assaults where private attorneys have just volunteered their time to help me on the case. And, and have actually appeared with me, next to me, free of charge to help out. And that assistance has been invaluable. And I know that the public defender's office, I tried to reciprocate, and other attorneys in the public defender's office, are there as a resource for the private defense bar. So if there's a new attorney, go ask the Tim Henderson or the Virginia A. Bear or the Yolanda Fair, Carrie Glasso Grant. I will say my experience is anybody in the public defender's office would be willing to help, and I think they also know that anybody
Absolutely.
in the private bar is willing to help them. So
yeah, absolutely. Totally. That's been my experience. It's I think having that maybe trickle down effect of bringing this attitude of invitation to the courtroom. Again, that's always what I felt from you, but that was always also what I felt from every other public defender that I've talked to, is just, they're there to help support. And it's a pretty cool thing to see, as many assistants kind of bringing that same attitude to the courtroom in terms of helping members of the private defense bar as a really powerful resource. So I think maybe kind of where we could kind of end the conversation, LeAnn, is again, you've kind of seen so much in terms of the changes moving from kind of a punishment based to kind of more of a treatment based court system. In terms of some of the changes that we might expect to see over the next decade based on kind of where things have gone in the past, what are some of the things that you kind of expect to see in terms of changes in the criminal process moving forward?
Can I call it my wish list?
That sounds good. I like that. Yeah, we can start singing. What is it, Mariah Carey or something?
So I mean, these are things that I would like to see happen. I think some of them will. I think some of them need to be pushed more. I think I would love to see during COVID, the public defender's office had the time to staff first appearances, which I think is a game changer to be able. And I actually think it's ultimately constitutionally required that we need to be at first appearances, because I do think that is a critical stage. I think it's ultimately going to be that public defenders will staff in custody first appearances and out of custody first appearances. I think a lot of individuals plead guilty at their first appearance, even when they're out of custody, without the advice of counsel.
Yes. Yeah.
When they would have that diversion opportunity, or if somebody just spoke on their behalf to the district attorney, that charge would get dismissed. So I think that will eventually happen, and I want that to happen. My big wish list is our bail policy. There's in Alamance County, the ACLU sued Alamance County on their bail practices, and they modified their bail policy. And part of that was requiring findings of ability to pay a secured bond, and the court making written findings. I think eventually our bail policy will require, I hope, let me just say I hope, that's on my wish list, that magistrates make written findings when they oppose a secured bond, and when the judge makes a finding of a secured bond, that it has to be in writing. I mean, I know as a defense attorney, sometimes a judge will impose a secured bond or not reduce the bond from a secured bond, and I just don't know why. Some judges are good at explaining why.
Right.
But if I knew the reason why, maybe I could point out the reason why maybe that's not the case. So
or try to go and get those things addressed and then come back and come, before the court on a, another day to ask for the same modification.
Yeah. So I hope that happens. I would like, I think there are many people that may disagree with me, but I would like for district court to become a court of record. I think, it makes it more accountable. I think we have a great district court judiciary, but I think, in terms of if there's ever a question about what is said in court, it would be nice to have a record. What did the prosecution witness say? Why did the judge make this decision? Why did the DA do this? Why did the public defender make this argument versus that argument? It makes the system, I think, more accountable if it's a court of record.
Yeah, and I think the technology exists to do that at a pretty, cost-effective means. So again, it's one of those things that as you're kind of looking back over why maybe this wasn't the case in the past and why it, could be possible now, there is just a difference in terms of kind of what the cost of putting that into practice would look like at this point.
And I do think we'll end up having more virtual hearings or virtual pleas. I would love if we could have like a consent court where you have, periodically every so often have a day set aside for the judge where, the defense attorney and the district attorney's office and the client, they've all reached an agreement. And then you have these cases on the docket, it's all done by consent, and you
Right.
could handle a whole bunch of cases at one time. I think, and it would save, people from missing time from work.
Right.
To be able to do that, have a set day for people to be able to move a case up and handle it early. I think we'll eventually, especially with COVID and the backlog of criminal jury trials, I think you're gonna have to see H&I felony pleas again in district court. I think to help address that backlog. I know the legislature a number of years ago, and this they made the statute where for a judge to waive court costs, you had to make these written findings of
Right.
just cause. I would love, again, this is a huge wish list. I would love for the legislature to flip that, to make it be a written finding of an ability that the person has the ability to pay those court costs.
Yes. Yeah.
Before they're actually imposed, have an automatic waiver unless the court determines that the person has the ability to pay. Just the fines and fees in the court system, in terms of clients who are poor, it just has such a snowball effect in terms of the detriment that it can do to someone. So I would like to for the court costs, which I think are somewhere around $250 or $300 now in district court, and that's
Yep.
a lot of money for somebody who has a public defender. So
It is. Yeah. No, I love that. I think it's I think it's actually good to characterize that as a wish list versus where do I see things go? Because I've actually asked this question to a couple of different guests on the podcast now, and most people have kind of just like tried to be the fortune teller of where do we go. I like the wish list format better because it actually kind of gives us a little bit more accountability in terms of kind of making those things happen, right? Like if it's kind of on the wish list, then whatever we can do to kind of make those things occur versus just here's where we're headed and there's no stopping this thing from going on, or just kind of vague predictions. I really like the wish list idea. So maybe our listeners, whether they're kind of going to adopt your wish list or their own, you're the one that can make it happen. It's not to be left to somebody else. If you want to see a change in criminal justice, then it starts with you. So I really like the wish list model. So LeAnn, I appreciate so much you coming on the podcast, taking your time to share, your insights from your many years of experience with us. It's been a tremendous blessing.
well, thank you so much for having me.
Hope you enjoyed today's episode of the podcast. If you did, please share the podcast with another freedom fighter in the criminal defense community, and be sure to leave us a rating on iTunes. See you next time.